attention to this issue. They deserve a round of applause, right? I do so much speaking, and when people say, where are the judges? There are no judges in the room. The judges need to be here. And I can't tell you how many times that has happened. And so what a pleasure and an honor to be here with so many judges participating in this conference. I have 30 minutes, and I'm going to talk about the most important federal piece of child welfare legislation in the last decade, one that does so much, or has the promise of doing so much to enhance what we do for children who are removed from home and placed in foster care. One that can do so much to transform the way our legal and judicial system aids in working with our child welfare agencies to enhance permanency and successful transitions for youth who have been abused and neglected. So this is a very important law that obviously demands more time than 30 minutes, so we'll give you a flavor through the PowerPoint slides, but and you have the PowerPoint slides on your USB flash drive, so you will have everything up here, but I'm going to be available throughout the day. I present later this afternoon at the end of the day on issues related to with my colleague Bill Scott, on non-custodial fathers and the child welfare system, a very important topic we're working on. But in between that session at the end of the day, and now I'm here if anybody would like to talk to me about anything that I discuss in this law. And I'm going to be talking about the 7 key areas, and obviously I'm not going to have real time to devote adequate attention to each one of these 7 areas of focus. The first that I want to cover is support of relative caretakers as alternatives to children being in traditional foster care. And what the Act does is it intends that we do a better job right up front in notifying adult relatives. Now that includes the paternal side as well as the maternal side of the family. It includes obviously the father who may not be living in the home. It includes uncles and aunts, and the Act doesn't say anything about limiting notice to those who reside in the state of Nebraska. So there are interesting challenges in this law for out-of-state and I would say out-of-country relatives, because it is the intent of Congress that they receive appropriate notice. It's a new Title 40 state plan requirement. And there must be due diligence in providing that notice within 30 days, and the notice has to assure that the recipients of notice understand their right to come forward and their potential ability to take care and custody of the child, including with federal financial and state financial support. I don't have time to go through all the opportunities for lawyers and judges in helping implement this law in Nebraska. And I know the Nebraska legislature has already taken some steps to work on state legislation that would track the Fostering Connections Act. But certainly this 30-day notice requirement is something that should be we should be conscious of. 30 days after removal, we need to get the relatives notified. On this slide, we want to encourage more relatives to be foster families and guardians. And the federal law sets up a new guardianship program with federal supported dollars. And this is very important that we now are looking not just for temporary care from relatives, but potential permanent care for relatives, and with the ability to not have to terminate parental rights, but to provide a structured permanent guardianship that would be supported not only with state funds, but for the first time with federal funds. And all of this starts, of course, in the federal fiscal year that begins October 1st. So we are not that far away from a period in which much of this act will be fully operational. Again, I'm sorry I don't have time to go through everything on these slides, and I'm really hitting the highlights. But you see that there are provisions that to try to make it easier for relative caretakers to provide alternative care for children. And one of the challenges we have is to find ways of using all appropriate technologies to find both maternal and maternal relatives. And states need to share information about that. I hope you have a regional implementation center at the university that can hopefully help you in identifying the technologies that can aid in family finding for these children who may have relatives who can come forward and take responsibility for their care. Kids who leave foster care at 16 or later, age 16 or later, there are a number of provisions in the Fostering Connections Act designed specifically to provide, to assure services for older children in care. And one of the important provisions in this act is if you leave a foster care at 16 or later and you're living in a relative guardianship situation, you are still eligible for independent living services and education training vouchers. This is very important. If we're serious about relatives taking over care for youth, particularly older youth, we want to be sure that that the youth can still get the services that they would get if they were in traditional foster care. And the provision that is optional for states is this number 11 at the bottom, permanent relative guardianship subsidies for youth after they turn 18. The option of having the federal government support the state of Nebraska in the cost of providing relative guardianship subsidies and keeping kids in foster care as well with federal support until age 21. And too many states have had policies and practices that have resulted in most youth at age 18 exiting the foster care system entirely and not receiving any further support. And one of the challenges is raised because there are so many judges here, is the importance of having the juvenile court have your authority to exercise continued jurisdiction over cases of youth who are still in the foster care system, or where there is still a need for monitoring their transitional services past their 18th birthday. So the important question is, do we have authority in law in the state of Nebraska for the juvenile court to maintain and continue dependency jurisdiction after a child turns 18? And that should be only with the youth's consent. They should certainly have the right not to have the juvenile court have a say in their life after they turn 18. They should have the right to exit foster care and be on their own as well. But too many states, and I believe Nebraska is among them, don't have clear jurisdictional authority for the juvenile court, dependency court, to continue its jurisdiction up to age 21, up to a youth turning age 21. And you know, in the situation of juvenile delinquency around the country, many states give authority when the judge has reported a child committed to a state agency or placed a child on probation for the court to still be involved past the 18th birthday. And it just doesn't make sense for courts with the Fostering Connections Act now in place. It doesn't make sense for courts to put themselves out of operation in handling cases of youth once they turn 18, but to have the ability to do so. That obviously puts more challenges on courts, means more cases on the docket will continue to be on the docket to require periodic reviews, but we shouldn't be stopping our involvement and our concern for these youth when they turn 18. We wouldn't do so for our own kids when they turn 18. Many of whom are not ready to be on their own. I know this because I have an 18-year-old, and you made the mistake in Nebraska of lowering your safe haven law back down to very young children. I wish you had increased it to age 19 so I could have brought my son with me on this trip. But we know kids are not ready most kids at age 18. There is money, and now the lawyers in the room need to know this. There is money in that the law intends to be made available to assure that when relatives need legal help in securing these guardianships, there's up to $2,000 supposed to be available for the legal fees, for assuring that legal help is available to relative caretakers wishing to obtain these guardianships. So I think this is a challenge for the state bar and for lawyers in general. Are we going to mobilize a group of attorneys with the expertise to obtain these guardianships that are now contemplated as permanent solutions for children who cannot be or will not be adopted? The Act puts a lot of importance on the outcomes for older youth. I've already mentioned the option to extend federally supported foster care through age 21. And there is an important provision to assure that states don't deny 4E coverage for older youth who are past age 18 in GED, job readiness, or training programs who are employed part-time or incapable of work due to disability. We want to assure that if the state opts for covering these youth who have reached their 18th birthday with federal support, that the support not end simply because the older youth are in a job readiness or training program or employed part-time or have a disability. If a youth is adopted after their 16th birthday, there is a provision that allows the 4E dollars to continue. I'm going to talk more about this in a few minutes about the adoption-related provisions of the Act. But the intent here is to try to assure that we provide adoptive parents and guardianship parents with the financial resources needed to provide for the former foster youth. The most important provision, I think, related to youth transitioning from care in the Act is this provision number 4, the mandated transition plan. It's required now by federal law within 90 days of the youth turning 18 or within 90 days prior to a later exit from the child welfare system. And that transition plan needs to be as detailed as the youth wishes. And if you read the federal law, which I encourage you to, there are elements that are mentioned that should be addressed in the transition plan. This should be a written document. It should be reviewed by the court. It should be made a part of the court record. And it's important that the court hold a hearing, at least to assure that the transition plan meets the approval of all the relevant people, and especially the youth. Starting in October 1st of 2010, I mentioned that most of the provisions go into effect immediately. But in October 2010, that is when kids over 18 in independent living settings can remain FORI eligible if states elect that post-18 option. Siblings. There is a new, and I know there's a lot of coverage at this conference on reasonable efforts issues. Under the law, there's a new reasonable efforts requirement to keep siblings together, that they be placed together when removed from home, if in their best interests, or to have frequent visits with each other, unless those visits would be documented as harmful. The law really does intend that siblings be placed together, and as I'll mention, with the new adoption provisions, it even makes siblings who might not have otherwise been eligible for 4E subsidies to be eligible, because we want to make sure that siblings are covered as a group. So this is a very important provision. Judges need to be asking the questions about what the agency has done to keep the siblings together when children enter care. The lawyers and judges will certainly be interested in this provision that provides clarity that $40 can be used for training. The words used are staff of abuse and neglect courts, but clearly attorneys and CASA training is covered. That's training for lawyers who represent children, lawyers who represent parents, and lawyers who represent the agencies. And I understand that Nebraska is in the process of privatizing foster care. This also makes it very clear that training dollars can be used for private agency staff, and I hope that you will use those dollars to be sure that lawyers who are representing the private agencies that are going to be providing foster care services, I hope you will assure that they get a necessary training. And I think that training needs to go over this act in far more detail than I have time to do this morning. But of course, those dollars only flow. Those dollars only flow if the child welfare agencies agree to use the new dollars for legal training of both private agency staff and relative guardians and court staff and lawyers and CASAs. So the intent of the law is to support with federal dollars that training. It starts with a match of, I believe, 55%. And the percentage of the federal match will be increasing each year. So as time goes on, it will go up to 70% of the cost of training being borne by the federal government, federal dollars. So there should be no excuse that legal professionals and judges, there should be no excuse for them not to get the necessary training around the child welfare system. The education and healthcare access provisions are terribly important. I'm pleased, I believe that Nebraska has actually recently passed legislation to track these provisions of the Fostering Connections Act. The intent here is to assure that when children are in foster care, that they are in school full-time, that they have school stability. This is a new 4E case plan requirement. There needs to be cooperation between the child welfare agencies and the local education agencies. The children are not only supposed to be in school full-time, and there be accountability to assure that foster children are in school full-time, and that they have a school stability, but also that they're in the appropriate program to meet their needs. And in the health area, there is a new requirement for child welfare agencies to coordinate with health care programs and consult with Medicaid and healthcare experts to assure that all children in foster care are receiving appropriate healthcare services. And so there should be developed for each child welfare agency an oversight and coordination plan related to assuring that all children in care will receive appropriate physical, dental, and mental health care. And there should be a coordinated strategy. This is all from the statute, this language here on the left-hand side. The law contemplates that there will be initial and follow-up health screenings meeting reasonable standards of medical practice with healthcare needs monitored and treated. This is the Fostering Connections version of healthcare reform. But this is law now. This is law now. There's been a recognition by the pediatric community that too often children who are removed from their homes for abuse and neglect, who may have been receiving inadequate health care to begin with, that there is a need to assure that they get adequate health care, because too often kids in foster care have been deprived of adequate care. So you have a requirement for schedule for initial and follow-up health screenings, medical information being updated and appropriately shared, the potential for development and implementation of electronic health records, having a medical home for each child. So already we have built into this law principles to make to help assure that children in foster care get first-class health services. There's also language in the Act related to oversight of prescription medication. Children in foster care often receive over-prescription of medication, and in some cases they don't get the medication that they need. They don't have prescriptions for the medication they need. So there needs to be clear oversight by the agency, and I would say by the court as well, of prescription medications for children in care, an active consultation and involvement by caseworkers with physicians and other appropriate medical or non-medical professionals in assessing child health and well-being and in determining appropriate medical treatment for the children. And I hope what this will lead to is child welfare agencies all having medical offices, either on the staff or under contract, or under some arrangement where there is someone that the agency can turn to assure that these provisions are effectively implemented. Strengthening adoption. The Act is called the Fostering Connections for Success and Increasing Adoptions Act. So strengthening adoption is a particularly important thing. Prospective adoptive parents need to be told about adoption tax credit availability. There has long been federal law to give tax credits for those who adopt children from the foster care system, and who adopt children generally. And most importantly, there is a provision to revise and expand eligibility for adoption subsidies. Now, I don't know what percentage of children who have been in foster care in Nebraska wind up getting adopted with federally supported adoption subsidies. Typically, the eligibility for an adoption subsidy has been based on the income of the parents from whom the child had been removed. This is what we call the 4E means test. Well, that is gradually being eliminated. And starting October 1st, every child who has turned 16 or will turn 16 during the coming federal fiscal year, which starts October 1st, if they need this, if their adopted families need an adoption subsidy to make their adoption possible, they will be eligible regardless of the income of their birth parents. Also, beginning October 1st, all foster children who have been in care for 60 consecutive months, so our kids who have been stuck in care the longest, regardless of the income of their biological parents or in the home from which they have been removed, but regardless of that income, all foster children who have been in care for 60 consecutive months will be eligible for their adoptive families receiving federally supported adoption subsidies. And finally, the siblings of either the 16 and overs or the siblings of the kids who have been in care for 60 consecutive months or longer, their siblings, regardless of age or time in care, will also, as of October 1st, be eligible for federally supported adoption subsidies. I really am not an expert on the Indian tribe-related provisions of the Act, but the intent here is to have better cooperation and coordination between child welfare agencies and Native American tribes. Native American tribes, for the first time under this Act, become eligible to receive Title IV-E federal payments, but the states still are going to be utilizing their IV-E dollars on behalf of Native American children, and they need to coordinate with the tribes in a more effective way and help the tribes in their development of Title IV-E plans. And the last thing I want to say in my very limited time is the only excuse for delays in implementing this legislation is if new legislation is required, and there is some language in the Act for limited delays if new legislation is required to implement certain provisions. So it's a challenge for lawyers and judges to identify what needs to be changed in Nebraska law, to prepare models or samples of such statutory language and otherwise provide assistance in the development of new laws to help states comply with these laws. The federal government has already issued some guidance to help states. There have been at least 3 policy issuances since the Act was passed. And I urge you to read those. The most recent one was on August 26th, not all that long ago, just a few weeks ago, on the use of IV-E adoption subsidies and the availability for expanded use of those subsidies. Well, 30 minutes goes fast, and I know that I am just about at that time. So unfortunately, I don't think the 30 minutes gives time for questions. And I'm looking to maybe one. Yes. Well, this is probably a good point for me to give my disclaimer in response to that, in that I can't, the views that I express about the law are my own interpretations. They don't represent the official positions unless I noted so, the official positions of the Department of Health and Human Services or the ABA. And we really do need to see more guidance to the states on these issues. I can't answer your question about what impact at one point a no reasonable effort planning will have far down the road in terms of eligibility for other 4E benefits and services. I think that is something that we need clarity on, and because we're going to have kids in care for a longer period of time. Actually, I hope we're going to have kids in care for shorter periods of time. The whole goal here is to get kids out of foster care quickly, to reduce foster care. I believe that this relative care provision, notice to relatives, is the single most important thing under this act that we can do to reduce racial disparities in the child welfare system. I think it is the most important thing we can do to significantly lower the number of children in foster care, to look to the relatives, to look at safety in terms of relative places, not to compromise safety for children. The Act says that pretty clearly, not to compromise safety, but to utilize both the maternal and the paternal side of the family as resources. You want to learn more about the paternal side of the family issue, come to our session at 4:15 this afternoon to hear about the involvement of non-resident fathers in maternal care. Sorry, I really don't have time to take another question, but I will stick around and try to answer your questions as you see me during the day. Thank you very much.